A Supreme Court ruling will now allow a North Carolina mother and her son to sue a public school system and a doctors group for allegedly giving the boy a COVID-19 vaccine without consent. The ruling reverses a lower court decision that a federal health emergency law prevented Emily Happel and her son Tanner Smith from filing a lawsuit. That suit says that the teen went to a school COVID clinic to be tested after several cases among his school's football team. He did not anticipate that the clinic would also be administering vaccines, and that's when allegedly he was given the shot.
We are bringing back in our chief legal analyst, Khalif Rhodes, one final time. All right, as I look at this, I immediately, as a parent, I get the knee-jerk reaction of going, I don't care what kind of law the clinic or the school has. My child said no. I didn't send a parental consent form with him. You can't just do what you want to do.
100%. As a parent of 4, I'm saying the same thing. I'm like, wow, this is disturbing. We saw this yesterday. I'm like, we'll be all over this tomorrow morning. I can't wait to digest it. But then when you take and start to pull away and peel away at the arguments, I start to step back and put my legal hat on. I think the majority, they ruled 5-2 in this situation. But looking at the dissent, I think if we're not talking about COVID, because I think it raises a couple, emotions out of folks. If we're not talking about child's health, I think it raises a couple emotions. But if you boil this argument down to what this really was, this is a supremacy clause. That federal law would trump state law in 99% of the cases. But in this situation, Justice Newby wrote that because it wasn't a tort, this federal law that protected, that normally gave immunity to these type of instances, does not protect in this case. And so in the dissent, Judge Riggs, who's been at the center of a back and forth judicial race trying to make sure her seat is secured, she wrote an opinion that said, look, this is unfounded by history. There's no precedent for this type of ruling to come down from the court, because traditionally, if there's a federal law, that federal law would every time trump state law.
Okay, so back it up a little bit and explain the federal law there, because there are certain things that happen when you have a public health emergency that allow health professionals to act in a certain way. But can you break down more of the legalese for us?
You're talking about PrEP. This is the Public Readiness and Emergency Preparedness Act that shields, that gives immunity. It's similar to qualified immunity with law enforcement. Because they're in a situation where they're putting their life on the line, there is going to be this additional burden that needs to be placed on individuals attempting to bring a claim against them. Well, in the same instance where you have individuals that are trying to stop a public health crisis, i.e. COVID, that was happening during this time, there was a raised bar for individuals to bring a claim against them because they were in the middle of the battle. They were on the front line. And when you have folks on the front line, you want to give them this additional protection, specifically hospitals, schools, institutions that are placing themselves in a position to give medication to ensure that this vaccine was provided and that the crisis was slowed down. So that is like, okay, that's the benefit for the bargain. If I'm going to allow you to be out here, or I should say ask you to go out here and to do these things, I'll ensure that on the back end, I will protect you. So the lower court, the next level court up, the Court of Appeals, they all agreed with that federal protection that protected these folks from being and having a lawsuit brought against them. Not that they, have been found liable, but would this even be able to be brought? Can this claim even go forward? That's what we're saying right here. Because typically, these types of claims would be stopped at the door. The person files the complaint, they want to have their day in court, and then the defendant will say, hey, I have this protection around me, you can't bring this claim.
Okay, so had there not been a medical emergency, typically the parent's rights would trump in this situation. But because of this going forward, as a parent, I need to know, it doesn't matter what my rights are, if there's an emergency going on. I mean, is that the precedent that might be set going forward, is the federal government might be able to sort of have the hierarchy there?
99% of the time, that's the right answer. In this situation, federal law would trump state law. In this case, the court ruled in our state, North Carolina, that this family would be able to go forward with their lawsuit.
Khalif Rhodes there. That's why he makes the big bucks, to break down the legalese for you, so you don't have to go up there and Google and get yourself confused. Khalif, we appreciate it.